According to the plea, the state is proceeding on count 1, paragraph A. Punishment is to be assessed at 30 years in the prison. There's a $1,500 fine. Affirmative finding of deadly weapon. No applications. You're not eligible. There's an affirmative finding of family violence. With an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition.
A plea hearing can sound routine at first. Paperwork, waivers, a few careful questions. But then Judge Boyd reaches the actual terms of the agreement, and the whole courtroom changes. This is not a small consequence. It is a serious plea with a long sentence, strict findings, and one final decision from the bench. Watch how Judge Boyd walks the record from procedure to final judgment.
Court is calling 2024 CR 012899, State versus Constance Sewell. Could I have parties announced for the record?
Against for the state.
Oh, okay, let me see. See, my glasses are for distance. So it's 2024 CR 012889. Oh, no, that's what it is. I probably said it incorrectly. Could parties re-announce for the record?
Yes.
Eric Baker for the defendant, Judge.
And are you Ms. Sinwell?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Sinwell, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are not going to proceed on paragraph A, the paragraph B is up to.
No objection.
So I'm sorry, because you're waiving count 1, paragraph B?
Yes, ma'am. Proceeding on paragraph A.
Okay. And you're waiving count 2?
Yes.
And you said there are no objections.
Correct, Judge.
All right. Ms. Sinwell, did you review the court admonishments with your attorney? Did you understand it, sign it in all the appropriate places?
Yes, ma'am.
All right. In count 1, paragraph A, you're charged with murder. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Judge, yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Sinwell, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count 1, paragraph A. Punishment is to be assessed at 30 years in the prison. There's a $1,500 fine. Affirmative finding of deadly weapon. No applications. You're not eligible. There's an affirmative finding of family violence. With an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. And you're not allowed to be designated as primary custodial parent. Did you understand that to be your plea bargain agreement?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, ma'am.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to count 1, paragraph A, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence.
Yes, Your Honor. State proper states exhibit 1.
No
Okay.
objection. Oh,
Okay, well, this is exhibit A1 as well.
no
Any
objection.
objections?
No, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witness statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and considered stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge, we'd like to.
Yes, Your Honor.
All right, anything you wish to say on behalf of your client?
Your Honor, I just briefly, my client is today, well, she's about 63. She'll turn 63 April 30th. I will point out that aside from the circumstances of this case, my client has never had any adverse contact with law enforcement whatsoever, no misdemeanors, no felonies. This case was pretty complex, Judge, from a family dynamic standpoint, and I want to just let the court know the state and I have been working very hard to try to balance all the interests in this case. The family's been very involved in the process also, talking to both sides. My client from day one has taken responsibility. From day one, she said, I do not want a jury trial. I want to take responsibility for this. Of course, Judge, we had to work through some things to get that sanity proceedings, et cetera, which we went through before we could enter this plea, having done our due diligence first. I think, Judge, 30 years is a good balance between punishment for this crime and also taking into consideration her age, criminal record, and the wishes of the family, Judge. And I'd ask you to follow the plea bargain in this case.
All right, the court will follow your agreement. The court, as previously stated, is finding you guilty of count 1, paragraph A. The court will sentence you to 30 years in the prison. There's a $1,500 fine, affirmative finding of family violence, credit for any time served, and there's an affirmative finding of deadly weapon. Is there anything else with regards to sentencing?
Judge, only that this case did involve some controlled substances, and I'm wondering if the court would recommend her for the therapeutic community.
Yes, I will. With regards to the therapeutic community, you'll have to ask for it as well. I have no jurisdiction to force them, to order them to place you in the program. Counsel.
Oh, thank you, Judge. All right.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you, okay?
Yeah.
The next case brings a different kind of pressure. This defendant is not only facing sentence, he is facing a choice about what kind of structure he can actually handle. Judge Boyd lays out the options clearly, and the answer he gives changes the direction of the hearing. Sometimes the most revealing courtroom moment is not the plea. It is the choice made after it.
Court is calling 2025 CR 013993 State versus Lupe Torres. Can I have parties announced?
Denny Callahan defense.
Of course.
All right.
Good morning, Your Honor.
Good morning. We are here for sentencing. You entered a no contest plea. It states that the TAP evaluation was completed. However, PSI was waived. According to your plea bargain agreement, punishment is to be assessed at 2 years. There's $1,000 fine, and the state is opposed to your application. Have both parties had a chance to review the TAP evaluation?
Yes, Your Honor.
Any objection to the TAP evaluation?
On page 1, it suggests that he used marijuana and methamphetamine. What he tried to say to her was he tried it, not used it. That's all, Your Honor.
All right. Any witnesses state? Defense, any witnesses?
No, Your Honor, allocution.
All right. The court will hear you state. You may proceed.
We have to deny application for Mr. Torres. Mr. Torres seems to be.
All right.
Your Honor, I suggest to the court that his problem is drug usage, which you can handle and fix with supervision on deferred adjudication. I believe he wants to address the court, Your Honor.
Yes.
Yes, ma'am. I haven't been in trouble in over 20 years.
I did go back. She called me to go help her clean her house, and there was.
Oh, I'm sorry, could you, just one moment. Solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God. All right, you can lower your hand, state your name for the record.
My name is Luca Torres.
All right, you may proceed.
May he allocute and give.
Yes. Yes, he may.
Okay, so I haven't been in trouble in over 20 years, so stay out of the way and everybody's way. With over 3 years ago, I was in a car accident. My wife left me, and there was a downfall from there. Met this girl, and everything happened. And I had that lady interview me, and she was kind of in a hurry, asking me, give me dates, give me dates. And I don't remember these dates. I try to estimate the time frame. I said about 2005, and she was getting upset. But anyways,
When you're talking about the lady, you're talking about the lady who did the TAP evaluation?
Yes, ma'am.
All right.
So she was kind of hurrying me up, and I tried to give her the best time, the best estimated time. I said, but
All
I
right,
got
here's my question for you.
Yes, ma'am.
TAP evaluation says you need inpatient treatment. What are your thoughts?
I say treatment is good. The services you provide, I can use. I'm not denying it, because temptation's out there, and
I know they're saying you need inpatient treatment. So even if I were to consider your, well, I am considering your application, but for me to even grant your application, you would still be in custody because you would be going into an inpatient treatment facility.
I really don't like it. I do outpatient because miss my family, and like I said, 3 years of being alone. My daughter came this year to come be with me, pick me up and take me to California, and this happened. She's the one that's my backbone and keeps me straight. I can do outpatient out there, and
Now, I want you to hear me and internalize what I'm saying. I am not, if I grant your application, you're not getting outpatient treatment. It's obvious to the court that if I were to grant your application, you need inpatient treatment. And what I can tell you, the inpatient treatment you need is 9 months. And you would have to wait in custody to be transferred to the inpatient treatment facility. Or, the state has made an offer of 2 years, and 2 years is the minimum. And you'll receive credit for any time that you've been in custody.
and I would have to go through the 9 months and then get out on probation.
Yes, you'd have to do 9 months at the treatment facility because that's the length of time for it. And then after the 9 months, then there's 6 months of aftercare. And usually that takes place in a halfway house.
I would rather go do the time.
Okay. All right, then this is what the court will do. No, don't apologize. Here's the thing. You know yourself better than I do, better than your attorney does, and better than the state does. And sometimes it's hard to recognize because we're trying to, how do I put this? We're trying to say things that we think other people want to hear. And I understand, and there's no need to apologize.
I just want to go with my daughter. She'll.
Okay. Well, I can tell you, once I sentence you, you'll get credit for any time that you've been in custody. And then once you're released from prison, who knows, they may parole you from the jail. Your attorney can speak to you about that. But once you're done, you're done. All right, the court is going to find you guilty, sentence you to 2 years in the prison, give you credit for any time served. There's $1,000 fine, time and money will run concurrently. I'll request the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. It's just a program that is designed to help you maintain your sobriety. I do not have jurisdiction to force them to place you in the program, but they'll see in the judgment that I'm requesting it for you, and you will have to request it as well. So for example, your sentence is 2 years. If you're in that program and you don't complete it, they're not going to say, we're not releasing him because he hasn't completed the program. You understand? All right, counsel, I don't have the trial court certification. If you could do one for me.
Yes, Your Honor.
Thank you, State.
I'm sorry about everything.
No. Let me just tell you, there's no need to apologize to me. I understand. There are decisions that you make.
I was hoping to do a year and then go to California without paperwork or just to give it to my daughter.
Well, I can tell you in felony court, if it's a felony probation, you're not allowed to only do a year. Sometimes on probation, it can be transferred to another state, another county, but that's only after inpatient treatment is completed. And then with that transfer, what ends up happening, you're not allowed to go to the other place or transfer physically to that place until they accept your probation. So sometimes they'll say, we're not going to accept this person. And so you have to stay where you are.
So is this paperwork done? Is it?
Yes, once we do this, you will be done. You'll get whatever credit you've been in custody. You'll get that credit subtracted from the 2-year sentence. And maybe they'll parole you from the Bexar County Jail, maybe not. Your attorney can speak to you about that.
Can I stop this now and maybe you accept
Oh, I've already entered my sentence, and once I give a sentence and it's a legal sentence, there's nothing else for me to do, right? I know sometimes attorneys will do motions to reconsider, but those are not necessarily legal motions in the sense that I have a right to grant it.
kind of weigh it out and services y'all do provide out here,
Mhm.
I can use.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review it with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, okay?
Thank you,
You're
Judge.
welcome.
Across these two cases, Judge Boyd's courtroom shows two different versions of accountability. In the first, the court followed a serious plea agreement and made the consequence final on the record. In the second, Judge Boyd slowed the hearing down and made the defendant face the difference between supervised treatment and accepting time. That is what separates these hearings from simple courtroom clips. The ruling is not random. It is built from the record, the plea, the risks, and the choices made in front of the court. Comment which ruling you think carried more weight, and subscribe for more real Texas courtroom breakdowns. Every ruling has a reason. Court Beacon TV shows you both.